Very good afternoon to my lecturer, Ms. Jogisuri Ramamurthy. I'm Ms. Tilagodi Velu from BLC Blended Student. Today I'm going to present my presentation on final project on subject Human Resource Management Strategy on question of unfair dismissal or unlawful termination. I'm going to intro. In Malaysia, an unfair dismissal claim can be litigated either in the civil court or in the industrial court. Unfair dismissal is defined as termination of a contract of employment for unfair or inadmissible reason. Employees are entitled to be members of a trade union and to take part in union activities. Employers must establish that the dismissal was based on a substantial reasons such as gross misconduct, lack of qualification, incapability to perform assigned duties, or redundancy. The courts usually take the employee's statutory rights into account in unfair dismissal claims, and employers must carry out a domestic inquiry run according to natural justice. A fair hearing is essentially for a workman to be properly dismissed. And also explain about unlawful termination dismissal of the employers. Employers can file a representation under Section 20 of the Industrial Relation Act 1967 at the nearest Industrial Relation Department to reach a settlement between the employer and employee. The main provision is Section 20(1) of IRA, where a workman, irrespective of whether he is a member of a trade union of workmen or otherwise, considers that he has been dismissed without just cause or excuse by his employer, he may make representation in writing to the Director General to be reinstated in his former employment. The representation may be filed at the office of the Director General nearest to the place of employment from which the workman was dismissed. It should be noted, referring to IRA 1967, the meaning of workman is any person, including an apprentice employed by an employer under a contract of employment to work for hire or reward and for the purpose of any proceeding in relation to a trade dispute. Dispute includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of the dispute or worse dismissal. Discharge or retrenchment has led to that dispute. In brief, Section 20 RIRA 1967 explaining the words workman covering anybody includes apprentice that had been employed by the employer under contract of employment to work for the purpose of getting salary or income. Okay, the procedure for application. The employee must be a workman under IRA 1967 to file an action against the employer. In Cap Malaysia Holdings Berhad versus RB Gray, the judge stated that the director of the company had special position and responsibility towards the operation of the company. Okay. I'm going to briefly explain in Cap Malaysia Holdings Berhad versus RB Gray and Eno. The term workman refers to any person employed under a contract or employment, regardless of wages, levels, and titles, as long as they are not director or managing directors who have the function or authority deemed to be the directing mind of the company. Procedure: representation to the Director General of Industrial Relations. At the outset in the event of unfair dismissal, the aggrieved party may have to be personally go to the office to the Industrial Relation IR department, which is the nearest to his workplace, or write in to the Director General of Industrial Relation DGIR to make a representation for reinstatement within 60 days of dismissal under Section 20(1) and 1(1)(a) of the Act. Conciliation process. The Department of IR will initiate conciliation between the employers and workers to reach an amicable settlement. Parties will be informed via letter to attend the prefix conciliation. The DGIR will take steps to ensure the expeditious settlement, and if the conciliation fails, the DGIR will notify the MOHR. Reference to the individual. Industrial. The MOHR may refer representation to the industrial court for an award, depending on whether there is a fit and proper case for reference. If not, the workman can apply to the High Court for an order for certiorari to squash the MOHR's decision. Leave of court must be obtained before an application can be made. Mention of the case in the industrial court. If there is a referral of the representation to the industrial court, the workman will be duly informed by the IR department of the said outcome, and he may expect to receive a notice of mention from industrial court wherein the workman's attendance is compulsory. During the mention, the workman will be directed to prepare and to file a statement of case under Section 9 of the Industrial Court Rules 1967. The rules within the stipulated time are followed by a statement in reply to be filed by the employer. Section 10 of the rules. The employer and employee may seek representation in the industrial court, be it themselves or represented by officer of a trade union of employees or employers. They may also represent by lawyers by filling Form A and B as provided under Section 3 and 4 of the rules, which is subject to the permission of the chairman of the industrial court. In normal circumstance, such permission will be granted if there is no objection from the opposing party. Okay, for this case, award was given as provided under case law. The industrial court may give an award as follows: to reinstate the employee to his former employment with no loss of benefit or privilege, and the back wages is to be paid by the employer to the employee from the date of dismissal until the date of the industrial court's decision with a maximum period of 24 months. Any contractual bonuses and other payment which may have been distributed to employees during the absence of the employee may also be ordered to be paid to him. Alternatively, the industrial court may, rather than to order reinstatement, order compensation to be paid to the employee as a substitute for reinstatement. The compensation formula usually applied by the industrial court is 1 month's wages for every year of the employee's service and back wages from the date of dismissal up to the last day of the court hearing, capped with a similar maximum period of 24 months. However, if it's found that the employees have been dismissed without just cause or excuse, but he had contributed in some way to his dismissal and or has been gainfully employed since the dismissal, the industrial court may reduce the compensation sum accordingly. Okay, for this question, I have attached a contract of service also. Contract of service under the Employment Act 1955 is any agreement, whether oral or in writing, and whether express or implied, whereby one person agrees to employ another as an employee and that the other agrees to service his employer as his employee, and includes an apprenticeship contract. In Malaysia, having a written employment contract is not mandatory unless the contract of service for specific period exceeding 1 month or for the performance of a specified piece of work where the time reasonably required for the completion of the work exceed or may exceed 1 month. I have take 3 case law for regarding my question. First case, Chin Hin O (Para Limited versus Public Prosecutor. Here the fact, defendant company, which is a sawmill, was convicted under Section 16A (1) (c) of the Employees Provident Fund Ordinance 1951 for not paying contribution to the fund for its employee. The defendant company appealed. The issue is whether the four sawyers were severally employed by the appellant company so that they exceed between each of them and the company a contract of service, or whether they form a partnership which was contracting independently with the company to saw wood for the company. Held, the appellant company was able to discuss between an independent contractor and a servant by demonstrating that employer retained the power to direct and control the manner of doing the work. The manager had the right to terminate the servants of all the server, but not any particular one. Okay, second case law, Dr. A. Dutt versus Asunta Hospital, bracket 1981, bracket 1 MLJ 304. In this case, the industrial court had made an award which it held the appellant was a workman and that he had been dismissed without just cause or excuse. The court did not award restatement but instead awarded compensation in lieu of restatement amounting to 522,000. The respondent applied for an order of category to quash the award. The ground of application were that the appellant was not workman within the meaning of Industrial Relations Act 1967, that the industrial court wrongly held that the appellant had been dismissed without just cause or excuse. Lastly, the industrial court exceeded its jurisdiction in awarding compensation in lieu of reinstatement. The industrial court had no error in law or fact in arriving at its conclusion that the appellant was workman within the Industrial Relations Act 1967 Act 177. A claim for reinstatement in employment by a workman is a trade dispute between the employer and the claimant connected with the non-employment of the claimant, just as much as the complaint of a number of workmen through their trade union. Okay, the third case law which I will speak on, Sagran Vino versus PPG Coatings Malaysia Sdn Bhd. Okay, in 2012, our partner Donovan Chia represented PPG Coatings Malaysia Sdn Bhd company in a claim of unfair dismissal by a former employee. The industrial court found in favor of the company and dismissed the claimant's claim. In its reported decision, the industrial court laid down several important findings relating to the obligation of an employer in a retrenchment exercise. Background of the facts: the claimant was employed as a maintenance worker with PPG in November 2008. Pursuant to a restructuring of the PPG group of companies in the region, the claimant's position was made redundant and it was retrenched. Retrenchment benefit of approximately 54 months of the claimant's last drawn salary were paid to the claimant in recognition of his long service with the company. The claimant was dissatisfied with the retrenchment benefit provided and claimed unfair dismissal. The claimant alleged, among other things, that the company had failed to comply with the collective agreement entered into between the company and the union, and that there was a shortfall of retrenchment benefit in the sum of Rm 85,240 and 08 cents. Okay, here the finding of the court: the company had legitimate reason to retrench due to poor financial performance, and the claimant's claim was unfounded as the collective agreement only came into force after the claimant's retrenchment. Okay, overall general view. The article focused on the statutory provision governing remedy for unfair dismissal in employment, which stipulates reinstatement as the only remedy for unfair dismissal. In 1980, Parliament replaced the provision and retained reinstatement as the only relief for the unfairly dismissal workman. In Enterprise Corporation Syndrome, Hadvi Sugumaran Vanugopal, the industrial court recognized the workman's right to security tenure, which brings guaranteed regular income and security of tenure. In Dr. A. Dutt and Asunta Hospital, the industrial court held that the termination simplicities like a termination by contractual notice and for no reason would still be dismissal without just cause or excuse, and the industrial court may award reinstatement or compensation in lieu of reinstatement. C.P. Mills argued that the reinstatement order carries with it a prima facie right for the workmen to recover wages lost since the time of dismissal. Period to 1987, back wages were assessed from the date of dismissals to the last date of the hearing, but were limited to 24 months. In H.M. Shah Enterprise, the court ordered payment of compensation in lieu for the poor workman with a gross monthly salary of Rm 455. The current law governing mitigation of loss is the result to the federal court ruling in James Alfred's case. The court ordered payment of full back wages for a period of 8 years and 4 months from the date of dismissal to the last date to hearing. The court also ignored to take into account the fact that the workman was gainfully employed after his dismissal. The employer-employee relationship is both inevitable and owed due to the symbiotic nature of the relationship and the egocentric character of both parties. The employer-employee relationship is symbiotic, but is not far from perfect. In former times, workers were considered higher slaves and discrimination and abuse were common. When the leftists gained political influence, the condition of the workers improved, but this did not solve the problem of self-serving ambition of both employers and employees. Okay, for this project and for the question, I have chose the Dr. A. V. Asunta Hospital. Okay, here the Dr. Dutt, an Indian national, brought a suit against Asunta Hospital for unreasonable dismissal. The industrial court awarded him 522,000 in lieu of reinstatement. The federal court concurred with a judgment and declared that termination simpliciter, which is not grounded on any cause or excuse, would enable the industrial court to award compensation if it would not order reinstatement. This ratio became a landmark in industrial law and a protective mantra to employees against unfair termination of service. In Dr. A. Dutt v. Asunta Hospital, is claim an absolute right to hire and fire any of these employees even in accordance with the terms of contract of employment. Okay, what consideration and process should your policy include? First, consider termination issue before the employees start work. Carefully draft the employment contract referring to the termination of employment provision. At the very least, state the agreed period of notice by each party. Okay. Second, have clear, unambiguous written policy covering a wide range of relevant workplace issues. These include probation periods, conduct in the workplace safety, sexual harassment, dress requirements, use of email, use of employer's property, attendance, timekeeping, termination procedure. Ensure this policy flag any misconduct that will be a serious breach of the employment contract. For example, this would include theft, poor performance, or insubordination. How to terminate an employee? Indicate the consequence of a breach. The most important details in this text are that termination must be lawful, have a valid person for the termination, be clear to both parties, comply with notice period, provide final payment,
Meet all documentation requirement. Collect all any employer property issued to the employee before the employee leaves. Get things in writing and set out in writing the actual date of termination of employment. This is important because an employee who feels the termination was not in accordance with their contract of legislative protection can take legal action. Important words of advice which we can don't and do. Okay, don't mischaracterize an employee issue. Take attitude an employee is guilty before finalized inquiry. Act in a defective manner when advising the employee to attend a meeting to discuss the allegation. Okay, which we must do. Allow the employee to have support person present when being interviewed. The Fair Work Ombudsman provides advice to both employers and employees on dismissal procedure and entitlements. Where employment is covered by state industrial relation legislation, for example, if your business is not incorporated, State Department of Employment, Industry Relations or similar title can provide advice on dismissal procedure and entitles. Unfair dismissal and unlawful termination can be costly endeavor for employees and employers. To prevent any unfair dismissal claims, employers must be compliant with legislation when terminating an employee. Okay, finally I came to conclusion. Unlawful dismissal can be reduced by educating employers about procedure and remedies. Arbitration proceeding delay and complicate attempts to be restricted or get compensation. Law provides guarantees to employees, but employers must follow principle to ensure justice is given. The Industrial Relations Act need to be reformatted to allow employees to claim damages instant to applying for reinstatement. This will reduce the time it takes for the industrial court to adjudicate grievances, as it is possible for employees to work back at the same office after being unlawfully terminated. Additionally, the process of referring the application to the minister should be looked into ensure it is necessary or not. The authority needs to take serious consideration to make necessary changes. And amendments in the Act. Section 20 of the IRS 1967 provides protection to an employee from unfair dismissal, but employers are allowed to terminate employment in a fair and reasonable manner. Dismissal can be lawful if the employee cannot properly carry out their job or is guilty of serious misconduct, or if they are unable to work for any reason. Employers must investigate the situation leading up to the termination and justify the dismissal, and if the employee behaves in an unreasonable manner, they may be dismissed without fear of retribution from tribunal. Thank you.